All right, welcome to Beyond Red and Blues. This is gonna be our first case law, down and dirty. We're gonna go with Pennsylvania Mimms, and I'll let Zach take it away.
Cool. So Pennsylvania versus Mimms, older case law, something that we use pretty much every day on routine traffic stops. And this pretty much covers, in the case of Pennsylvania versus Mimms, Mimms was stopped for driving with an expired license plate. He's asked to exit a vehicle, and when he exits the car, they see a bulge in his jacket. They conduct a search, and they end up finding a firearm on him. And the argument is, well, they shouldn't have asked him to step out of the vehicle because there was no articulation or reasonable suspicion that crime was afoot, if you will. He said it was a minor traffic violation, and that was the only reason. So it goes up to the Supreme Court, and the Supreme Court basically decides 6-3 that ordering someone out of the vehicle is lawful as long as the stop is. So if you stop someone for a legitimate reason, even if it's just a traffic violation, you can order them out of the vehicle. Now, this is specifically just for drivers, and it basically says whether crime is afoot or not, that traffic stops are inherently dangerous, and it's where a lot of officers are hurt and killed. And so it's a minor intrusion to detain them inside of the car, outside of the car, in the back seat, wherever it may be. It's a minor intrusion to the person, but a big gain in the officer's safety. So they sided on the officers on this. However, there is 3 that voted against it, and the 3 basically says that it gives a lot of discretion to police officers, allowing them to just remove and search people whenever they can invent a basis for concern. And so there is a legitimate concern that maybe it's overused sometimes. So do you need a reason to ask someone to step out? No. But is it always better to have a reason and to articulate it? And when it gets time for your report, explaining on your report that maybe he was moving around too much, or he was uncooperative, or he was, extremely nervous, and all these things that indicated to you that maybe there's some sort of officer safety concern. Does it need to be there? No. You could just ask him to step out, but it's always better, right? It's kind of like on our traffic stops, we're taught if someone has a headlight out and a tail light out and tinted windows and they're speeding, there's way more violations. Now your basis for detention is much, much stronger versus just speeding, because getting speeding thrown out can be easy, right? Are you trained properly? Did you really see it? It's kind of your word against theirs. And if you don't have a dash cam or anything, then maybe there's already questions. And if your PC or probable cause gets thrown out on that detention, then anything you find after isn't good. So it's kind of like asking them to step out is good to go, but having legitimate reasons even more, like I said, furtive movements and so on and so forth is even better. So that is Pennsylvania versus Mimms. There's a similar case law under Maryland versus Wilson, and this basically rules the exact same thing, but allows you to do so with passengers. So anybody that's in the front or back seat, doesn't matter. You're allowed to take out all the same under this officer safety concern. Again, adds a minor intrusion to them, but a big officer safety gain. So for no reason whatsoever, you can ask them to step out. Again, articulation is always better, but this case allows that discretion already.
Yeah, and there's also a case law on ordering people back into the vehicle as well. Sometimes, we've had it where people just, as soon as the car stops, they run out. They're like, oh, no, the passenger. So let me just clear with the passenger. They're like, oh, I don't want to be any part of this. It's between you and the driver. Well, no, it's not between just me and the driver. Get back in the car and sit down because you're part of this too now until I'm done. And I think you touched upon, I think the reason why the Supreme Court went 6-3 on this is the small inconvenience of someone stepping out of a vehicle does not outweigh the somewhat large officer safety risk, especially if it's at night or tinted windows, like you mentioned. You can't see in there, especially if that limo tent, which is illegal, but so many people have it. It just doesn't outweigh it, and I think that's why they went that way with it.
Yeah, correct. And when it comes to the passengers too, yeah, whenever a vehicle is stopped, all of the occupants are technically seized. So under the Fourth Amendment, right, you have the unreasonable search and seizure. Whenever a vehicle is stopped, all occupants are considered seized under the Fourth Amendment. And again, it's lawful, and we are able to do that. And once you're seized, we're able to control you. Now, there are other limitations, like we can't force you to identify and so on and so forth. But we can control your movements. We can order you out or order you back in, or whatever the movement is to justify that officer's safety. So yeah, just know, unfortunately, most of the business is going to be dealt with through the driver, but you are part of it. And a lot of states now are trying to move towards more accountability on officers. So officers are probably going to try to identify the passengers, because there's a lot of accountability nowadays where we have to log everybody that stopped and why we stopped them and what we did with these people and what we asked them and so on and so forth. So there's a lot of accountability now with law enforcement. And so they're going to ask you all these things. Some of it is because maybe they want to know, whether you're involved in some criminal activity, and some of it may just be more of this accountability on our end. So, know your rights, know when you have to identify and when you don't, but you are seized. You do have to follow their lawful orders. You can't just walk away or get out of the car and leave because you don't want to be a part of it.
Right. And they have this authority, regardless of the situation. They can order you out at any time for any reason. And that's what the Supreme Court backed up. Is just that, again, that minor inconvenience doesn't outweigh the officer's safety.
Yep.
So let's go to our challenge question for the week. We're going to leave you guys with a question, and then for next week on our case law, we'll give you the answer plus the next one. Okay, so let's say you conduct a traffic stop for failure to yield in a neighborhood. Let's say it's known for drug trafficking and violent crime. Your driver complies, but kind of unusually calm and nonchalant about it. So you ask him to exit the vehicle, but he questions your authority immediately. Unfortunately, you have no specific articulable suspicion of weapons or criminal activity of the driver beyond the minor traffic offense that you saw. So, two-part question. One, does Pennsylvania Mimms allow you to order the driver out of the vehicle in this situation? And then two, does the fact that you're in a high crime area legally change your authority to order that person out of the vehicle? So next week, we'll give you the answer. We'll let you guys munch on that one for a little bit. And we'll do another case law.
Yeah, if there's any case law that you guys are specifically looking for, please feel free to let us know. And we're going to try to cover all the big ones. So anything you guys are looking at, let us know. We'd be happy to look into it.
Sounds good. We'll see you guys next week.